Victims of domestic violence could soon have enhanced protections, and a lesser-known anti-bullying bill is examined in this week's Capitol Report. Hello, everybody, and welcome to this week's Capitol Report. I'm Julie Bartke. Victims of domestic violence could soon receive even more protection. Two bills were announced that are designed to tighten current laws.
Probable cause in these particular cases, because these are unwitnessed misdemeanors, we are given legislative authority to be able to make warrantless arrests within 24 hours. And that's really what's key in these domestic violence cases at the misdemeanor level. And so this legislation essentially expands that window and provides law enforcement the time necessary to seek and apprehend and bring into custody that offender.
Janae came to my office frightened. She told me her story. Years ago, when she was pregnant with her child, her intimate partner strangled and assaulted her. He was convicted of domestic assault by strangulation and was incarcerated. Even as he was behind bars, Janae still didn't feel safe. She feared he would find her when he got out. So she moved to a different part of Minnesota, seeking safety, looking for a fresh start. As his release date approached, she was nervous about where in Minnesota he would be released. Even though she had relocated her entire life, she worried. Would he be released 5 minutes or 5 hours away? Would he find her? Would he hurt her and the children again? Janae knew approximately when he would be released from prison, but the law said she couldn't know where he would be released when he got out. His release date arrived. The next day, he was outside Janae's home. He had found her. At that point, Janae came to my office terrified. In collaboration with the criminal justice system, we helped her and her children to safety. House File 2142 gives victims of domestic violence the right to the location of domestic violence offenders' residence upon release. If it becomes law, it could help survivors like Janae access information crucial to their safety.
Here to discuss two proposals that would tighten current domestic violence laws, we have Senator Vicki Jensen. Thanks for joining us, Senator.
Great to be here.
Senator, first of all, let's talk about the two proposals that were introduced, and how do you think they're going to impact the overall safety of victims of domestic violence?
Sure. There are two proposals. One deals with victims that someone has been incarcerated and served their time and they're going to be released. And basically, right now, currently, you are notified when they're going to be released, but you don't know where they're going. And how that would impact and help is that the person, the victim, has to set a safety plan for themselves. And if they don't know where the person is going to be, then their safety plan looks much different, and it's a lot harder for them to continue and go on with their life without having that ability to set a safety plan where they feel safe. Now, the other one has to do with when there is a situation and someone is called, the police come, and the person is gone from the scene. Current law says that if it's a certain offense, if it's a felony, or if it's a certain offense with an order of protection, that you have the ability to arrest without a warrant. And other ones, a gross misdemeanor, you would have only 24 hours to do that. And what that legislation would do would change that so that all of them you would be able to do a warrantless arrest. And it makes it a lot easier for the victim, it makes it easier for law enforcement, and then there can't be this ability for the person that's gone at the scene to avoid being arrested just by hiding out. I mean, they can be gone for 24 hours and then they can come back and...
And Senator, when I was reading up a little bit about your passion for this legislation, you work very closely with the Minnesota Coalition for Battered Women. Why is this such a personal issue for you?
You know, I experienced it personally, not myself, but within my family. And you can't describe what it's like to have the feeling that you could have, should have, what could I have done? And then the knowledge that when you're in that situation, you remove yourself from your friends, your family, and you're basically all alone. And that's the way that situation works. I worked for a long time after my sister was in a situation where her house exploded and she was burned 90% of her body, and her significant other was arrested and put on trial for attempted murder. He was found innocent. but he had had several orders of protection put against him. He had served time in jail for domestic violence offenses. So to come to the understanding as a family member that there has to be some of that protection and safety for that person, especially at a time when they decide to leave, and that's when it happened for her as well.
And Senator, 37 Minnesota women and men died last year because of domestic violence. Where does this legislation, these two pieces of legislation, fit in with the overall impact on keeping victims, potential victims, safe and maybe lowering that rate?
And like I said, you do isolate yourself, and that's why you end up, I think, in a lot of the situation you're in when you try to get out. And having organizations like the Minnesota Coalition for Battered Women and local communities that really try to get information out so that people know that they're not alone and that they don't have to endure this alone, and that the safety measures that we put in public safety for police are there to try to protect, but we also have to make sure that due process is followed. That has to be kept in mind as well, and that's what we're trying to do in this legislation. But if we can get that information out to women and men, that they have somewhere to go, that they can trust somebody and somebody will help them make these safety plans, that someone will go out and try to put somebody off of the street that is committing domestic violence, it will be better for them, and they'll be able to become a more productive person in the community, and their kids as well if they have kids.
And there's strong bipartisan support for both of these proposals. Do you have any intention of working with the Minnesota Coalition for Battered Women to advance this or create other pieces of legislation?
Absolutely. I think we have to have advocates at all levels in order for there to be real substantive change, especially how we talk about it, and that it's not something that should be kept secret. We have to let people know that this happens. And I'm hoping that there are other things, other legislation that will help, because there is a whole range of things that need to be looked at, and mental health, I think, is one of the big ones. And this ties in, I think, really well to some of that, because you're not healthy if you're having these kinds of situations happen, whether you're the abuser or the victim.
Okay. Senator Jensen, we will, of course, track your legislation and any future proposals as well. Thanks for joining us.
Absolutely. Thank you.
This committee signaled the first in a series of hearings to discuss inequities in health among Minnesotans. The ultimate goal is providing health equity.
Health is crucial to everything that happens in our state. I often use the quotation from Herophilus of Chalcedon, the physician to Alexander the Great. When health is absent, wisdom can't reveal itself, art cannot become manifest, strength cannot fight, wealth becomes useless, and intelligence cannot be applied. Without health, you really can't do all of the things that make this state a great place to live, a state that you want to live in, a state that really maximizes its potential. Health is central to that. And unless all parts of our community, all aspects of our population are benefiting from this healthy environment, from our healthcare system, from the programs and policies that really influence health, we're never going to be reach our maximum potential.
Senator Kathy Sheran is here to talk about the issue of health disparities in Minnesota. Thanks for joining us. We appreciate it.
I'm glad to be here.
Senator, you just held a hearing on this issue and stated that there's this goal of health equity. How achievable do you think this goal is?
Well, the data indicates that there's a great disparity between certain groups, populations, African Americans, Indians, the new Somali community, new immigrants, healthcare outcomes, and the general population. So when we're sort of bragging about how well we're doing in terms of improving people's life expectancy or reducing the number of birth deaths, we're talking about some of us, but not all of us. So this year, we've had this hearing, as a matter of fact, the hearing was today, to take a look at not just the existence of the problem, but what can we learn from certain groups in our community that work with groups that have disparate health outcomes to change that. And I think we can achieve movement if we focus on what it is that will change that rather than simply spend our time describing the problem.
So what are some of the things you think can motivate change? What are some of the things that do have to change?
Well, first of all, the legislature has to understand that being able to change a person's health status is more than simply having them come in and see their physician and have some kind of a antibiotic if they have an infection. There really has to be a cultural change in the community that the person lives in, and opportunities to do the things that result in health outcomes, that it is a broader issue than simply getting medical intervention. That's what we heard today in committee. It's about being able to have a job that earns enough income so that you can afford safe housing, that's environmentally clean, that there's enough income in the family to buy food that's healthy for the person to eat, that the state of Minnesota doesn't implement economic development policies that create an environmental problem for certain neighborhoods, that create lung disease or other kinds of problems for specific populations who are poor. So what we need to take a look at is not just access to a physician for medication or health care, but also to those things environmentally that create an environment that health can occur.
Health Commissioner Ed Ellinger stated that African Americans, as you talk about health status, have essentially twice the unhealthy lifestyle as whites. What do you think this means for the state?
Well, we do know, not just in healthcare, but in terms of incarceration across the board, African Americans have very, very different kind of picture than whites. So what this means for the state is that we have to deal with the consequences of that in our budgets. We have to pay for the consequences of a whole population of really capable, competent people who are not investing in. Instead, we're having to pay for the consequences of not making that investment. The public gets frustrated with that. The public doesn't like having to use its resources to make up for crime or to make up for chronic disease problems or chronic chemical dependency problems or other kinds of problems. They don't like having to sort of get at that end of the continuum. But if we don't want to spend our money there, then we have to spend our money on those things that will create health equity for everybody, and that includes a neighborhood that's safe to live in, a neighborhood that has affordable and clean housing, a job for somebody to be able to earn enough income so that they can purchase quality food. Those are the kinds of things that we heard this morning contribute to the reduction of health disparities.
So, Senator, what kind of a price tag do you anticipate with this? And it's not a budget year. Do you think you can move this forward?
I think there are elements that we'll have to focus on this year. There are things that can be done administratively, for example, that will not require any expenditure at all. And an example of that might be how we distribute the grants and what we expect of a grantee, recognizing that there are certain communities that can come forward and with that money have access to a community we'd like to change their health disparities. They might not be the traditional model, they may not be the Western model, they may be a new model. And so there are administrative things that can be done in granting resources to those organizations that really have access to this community.
Is that where you plan to go first?
Absolutely. I think absolutely administrative changes are the easy ones to do. Those are the ones that we can do off the top because they don't have dollar signs associated with them.
Senator, in addition to these administrative fixes you're talking about, what else can be done?
Well, the system has to be changed. As I said, we need to take a look at how we implement grants, who we hire in our departments to make sure the voices of special communities are heard so that we listen to how to approach those groups. But then there are other things that I heard this morning, and that is that in order to work with these special communities, you have to develop a trusting relationship. And until you establish that, the capacity for us to change the health disparities doesn't exist. We don't reimburse for time that it takes to develop relationships in healthcare. So we need to take a look at how are we going to be able, maybe through the accountable care organization model, where you bundle resources and say, serve a population with all of this money, and you decide how to utilize it best, so that we can reimburse those things that need to be foundational in developing an environment in which that community comes forward and seeks the information they need to reduce healthcare disparities.
And again, it's a short session. Can you accomplish a lot of these, do you think, in 2014?
Our goal is not to accomplish major change in 1 year when you're talking about cultural change and health disparities. This is the beginning of a process that will take a substantial period of time and commitment over a long period of time from the legislature.
Okay, Senator Kathy Sheran, as always, thank you for coming in and sharing your perspective on this issue. We certainly appreciate it.
Thank you.
Last week on Capitol Report, we spoke with Senator Scott Dibble about his Safe and Supportive Schools Act, also known as an anti-bullying bill. Well, this week we are speaking with Republican Senator Roger Chamberlain about his anti-bullying legislation. Thanks for joining us, Senator.
Thank you for having me.
Senator, before we actually talk about your proposal, I want to ask you about something that you wrote about in an op-ed, and you stated that you were bullied in school. So obviously this is a personal issue for you.
Sure. I mean, myself, like many others, we went through. We were bullied, glasses, tall, skinny, that sort of thing. So I understand it, know what it's like. It's not fun. It's no good. And to that extent, we want to prevent it and stop it whenever we can. So yes.
And so what would your proposal do?
Well, we have a combination. We had a couple of amendments last year. One is a Gazelka amendment, my amendment. And what we're putting together with some other folks is simply, if our idea is that we don't necessarily need new legislation, but if Senator Dibble wants to compromise and work together, and there's some holes and things we can tighten up, we're willing to do it. His is 20 pages long, ours is 3. Ours offers a clear definition of bullying. It offers protections for data privacy and due process. It protects all children. Our bill protects all children and tightens up some of the requirements to satisfy the school board and teachers and educators. So our bill's short, sweet, tightens things up, does the job. We already have 3 laws in the books addressing bullying and violence in schools. 3 laws. The School Board Association's got a standard policy that most schools use, and it's very clear. It offers good guidance. We don't need 20 pages, $25 million unfunded mandate to burden the schools with. No teacher is talking to me about this. They don't want it. The school board is not supporting this.
A lot of education entities are supportive of Senator Dibble's proposal, but talking about yours, the school board is not in favor of his. You're saying that there's some support for yours, but I want to talk a little bit more about you. You said that yours offers guidance. So does that mean yours doesn't direct school boards to develop further legislation or further policies?
Senator Dibble's bill is very loose on data privacy. There's no requirements for destruction, how long they keep this data on these kids. When it's destroyed, what they can do with it, who can get it. Secondly, there's no due process. It's not required for them to contact the kids, the parents of either child. So the school runs amok. Well, the system runs amok. The schools are doing their job. There was some, I'd have to get the data, but kids in a recent survey said they feel safe and comfortable in schools. We don't need 20 pages of $25 million unfunded mandate imposed upon the schools. The school board, school associates, school groups, education groups, if they think, for them to push this bill forward, what's implied in the bill, it's implicit in the bill that they don't believe that teachers and educators are doing their job, they're violating the law, and they don't care about the kids. They are saying that teachers and educators don't care and are violating the law. I've been in these schools, you've been in the schools, we've all been in schools. I've had neighbors, friends, family members, teachers. They care about the kids. They care. They're doing their job. And Dibble's bill will ruin that.
Let's get back to your bill. You stated earlier that you didn't think new legislation was necessary, yet our current, the current true anti-bullying bill is 37 words long, and people across the board tend to agree that it is some of the weakest legislation in the nation, not just weak statewide standards. So how would yours strengthen it?
Well, if the standard is, if we're measuring effectiveness of law and by how many words we have, I think we go throughout history and throw a lot of stuff out and invalidate it. It's silly for people to say that the current law requiring schools to have a bullying policy because it's only 37 words long is no good. It's silly. Their explanation is, well, let's put a 20-page bill, try to manage every aspect of somebody's life, burden the schools and the teacher with something they don't have to do, and they can't possibly manage. So, but
do you see areas, though, that do need strengthening? I mean, you've talked data privacy here, so there've got to be some things.
Well, Bill, what he's doing with his bill requires more data privacy, more bureaucracy, more spending, more investigation, more safekeeping of data. if they just talk about the bullying law, there's a 1955 anti-discrimination law. 1989 is the model policy for schools, requiring schools to teach violence prevention, intimidation, harassment, teach that in schools. And in 2005, the bullying bill was passed saying the schools have to do this. School boards have a model policy that's very comprehensive that all the schools are doing and using. So it's there, it's being done, the educators are doing their job. Senator Dibble's bill is a bridge too far. It's a fire hose to water your house plants. It's just not needed.
And we're almost out of time, Senator,
Sure.
but as a member of the minority caucus, what can you do now moving forward to try to secure a hearing or get some momentum going on your proposal?
You know, Senator Dibble and the Democrats are great about asking for compromise. And I believe that they should stop and work with us on this bill. We see what happens when they push stuff through. If you like Minsure, this bill is one of the most destructive K-12 pieces of legislation in the last 40 years. I say that sincerely with my heart. It is not needed, it's destructive, it's burdensome, it's going to do great harm to the schools and to the education environment of the state. We have effective policies and laws now. It's just simply not needed, it's overreach. And I certainly hope that Senator Dibble stops and listens to some other folks, because it's going to be his bill and the Democrats are going to own this, just like they own Minsure. And there's not unanimous support. Senator Kuhn, I understand, is not very happy about this bill. And once more people learn about it, they're not supporting it. So this has not got vast, wide support that he likes to portray.
Okay, Senator Roger Chamberlain, thank you for your time today.
Thank you very much.
Minnesota could be the 30th state in the nation to compensate prisoners who were wrongfully convicted. Here to discuss his proposal on compensating those who were wrongfully imprisoned, we have Senator Ron Latz. Thanks for joining us. We appreciate your time.
My pleasure, Julie.
Senator, let's begin with explain just how your proposal would work.
The proposal is for persons who are exonerated after they've been convicted, served some time, and then new evidence is developed or a reevaluation of old evidence, and they're actually back in court and a judge declares that the evidence was insufficient to convict them, that it looks like they were innocent, and actually vacates the conviction and exonerates them. Then the conclusion is they were wrongfully imprisoned. And when they are released, the question is, should the government do anything to assist them in getting back on their feet, to compensate them for having spent years behind bars, away from their families, not earning a living, and what should we do as a government? So this proposal is our response to that question.
At your news conference when you announced this legislation, there were two men there who this had happened to, the two known cases in the state. Encapsulate for us, if you can, what their story is and how this could help them.
Sure. Well,
or others like them.
Yeah. Well, these are the two people that in the last 5 years were in this situation. There are some others that go back further, and there are others, of course, in other states in the country. That's why there are 29 states, plus the District of Columbia, plus the federal government that already have similar statutes to what I'm proposing here for compensating exonerees. In this case, there were two individuals. One we might already be familiar with, or the audience might be, because it involved the individual who drove his car. It was a Toyota, and the accelerator stuck, and he hit another vehicle on the off-ramp and caused a death as a result of that. He was convicted, but then later on, more information came out about Toyota's acceleration pedal sticking, and 3 years later, that evidence was reevaluated in court, and a judge exonerated him, declared that he had been innocent, actually, and was released from prison. The other case is someone who spent 7 years in prison for conviction for killing his infant child. It turns out that when everything was reviewed after the Minnesota Innocence Project took up the case, went back, brought in some additional experts, reviewed the evidence, the science, brought in some mechanical experts as well to look at the physical injuries to the child, that the overwhelming weight of the evidence was to conclude that the child had died from a head injury that had been sustained 4 or 5 days earlier in falling from a shopping cart, not relating to anything that the individual was charged with causing the death. So he was exonerated after spending almost 7 years behind bars.
And you're talking about a variety of time spent behind the bars. So how would this bill work? Would it compensate according to how long somebody was behind, was in jail wrongfully, or is there kind of a cap on it? How do you anticipate the financial part of this playing out?
The way the bill is written, it would be a sort of default payment of $50,000 per year of wrongful incarceration. There would be a total cap of payment or compensation of $700,000, and there would be some discretion in there for the administrative law judge to evaluate the individual case to see if there are particular circumstances that would justify a payment in excess of $50,000 per year. For example, if someone was a particularly high earner at the time, so that their wage loss or economic loss would be greater than $50,000 a year. And this is typically the way damages in tort cases are evaluated. You look at what's their lost wages and so on. If they had particularly young children and they were gone for a long time, so their kids grew up without them, might be an egregious situation as well. And then there's another piece to this bill, which is transitional costs for reintegrating into the community. Right now, if someone is convicted and they serve their time and they are released at the end of their sentence, still being convicted, not exonerated, the state provides transitional programming for them to reintegrate into society so they'll be successful and hopefully not commit new offenses. Help finding housing, help with job placement or workplace training, those kinds of things. Maybe ongoing chemical dependency treatment or assistance in getting into locally based programming like that. When we release someone who's been exonerated, their conviction's been vacated, they've been declared innocent essentially, we don't give them anything more than a pat on the back and wish them good luck. But they too have been away from their families and from the workplace. They've probably lost their jobs, may have lost their homes, may have lost their families. And so they're in a real tough position. We should give them the same kind of transitional help that we give others.
Senator, we are almost out of time here. As you mentioned earlier, there are 29 other states that have similar statutes. Did you pattern this after those, or did you find things that were not working in other states and changed our legislation accordingly?
Yeah, there were some other states that, for example, left it up to individual bills in a legislature on a case-by-case basis, and we didn't think that was the right way to go. It leaves it far too open to politics, and the dollar amounts might vary, and no consistency there. So we set up a program that would have some consistency, for one thing. But what we don't have right now in Minnesota, and maybe someday we will, is someone who spent, say, 25 or 30 years behind bars on a rape or a murder conviction, and later DNA evidence determines they weren't the person that committed the crime. Those are really egregious cases. And that's happened in other states. Illinois has had a few of those cases. And so we may look at how we're going to handle those kind of cases too.
Okay, Senator Ron Latz, we are out of time, but thank you for coming in. We appreciate it.
Thank you.
That concludes this week's program. From all of us at Senate Media Services, I'm Julie Barkey. Thank you for watching.